Welcome, welcome, welcome. Good evening, everybody. Welcome to Kitchen Court Cases, where we watch court in my kitchen. And tonight we have a fabulous show set up, and I'm so glad to see some of you here already. If you're new here, welcome. The drill goes a little something like this. Clock in for your shift by hitting that like button. Tell us in the chat what you had for dinner. And if you didn't like what you had for dinner, tell us what you wish you had. Steffi, thank you so much. Isn't it cute? I like it too. Also, before I forget, I don't know if Brian and Kimmy are here yet, but it is Brian's birthday tonight, so we can't forget that. And if it's your birthday, let us know. We don't like to forget any of our family's birthday. Okay, so who am I seeing? I got Courtney, I got Mayor, I got Trish, I've got Les. Oh, Les and Jody, thank you for your comment yesterday. I'm glad that your grandbabies came over. And don't worry about missing the live. I'm so glad you caught the replay, but I'm super glad to hear you had fun with the grandbabies. Um, Thank you, Mayor. My cleavage is nice. Sashina is here. Let's see here. Scroll down to the live. MB, hi friend. Hope you're well. Hinman. Oh, spicy chili cumin chicken in the Instant Pot. I like that. I might want the recipe. Mayor had a hot pocket. He's sad about it. Grammy Rita's birthday is Thursday the 29th. Okay, we have to remember that too. I'm experimenting with some things there, so we'll see. Nana was not happy about that, but that's not the point. Okay, what else? Lisa B, welcome, welcome. Lawrence, did you eat today? Lawrence, that's such a good reminder. If you're new here, sometimes we call out med check, or you might even see it in the chat because somebody got a little fancy today. So if you see something like that, something might come up if I did it right. Maybe not. But who knows? Maybe it was just meds. What I'm saying is in there are some new fun chat commands that should trigger some cool, fun things if you can figure them out. I can't, even though I just made them. So, who's to know? Anyways, Doodle Mom North Carolina's here. Les Gardner. Oh, you love homemade pickles? Yeah, who doesn't? Um, okay, Lisa's making her rice. She's gonna listen. That's fine, Lisa, but you gotta wash the rice, right? Wash that rice. Oh, beaver is not one yet. Is it? I don't know. I can't even remember. I literally made them. I can't remember. So we're going to get started. The first thing I want you to do is think about if you are already subbed to Tommy V and MI. He did a great video today, and I covered the same one, and he was super fast. So I want you guys to make sure that you're covering Tommy. You've got Tommy V and MI subbed. You're subbed to him because he's growing super fast. He's doing great work, and he is a friend of the channel, of course. Our Fulmer, thank you for clocking in, because there is even like what is it? Late? Seriously. Oh, Harmony, thank you for clocking in as well. Seriously, there's some like funny ones that I've done in there and I can't even remember. I'll give you a hint. Last names of a few judges should pop up a few little things. A few of the favorite judges, if you will. So, um, let's see here. Jojo, thank you for clocking in early and being subbed to Tommy V. And oh, yes, our Fulmer, just spell it L-E. I never thought anybody would get that one. Yes. Okay, so we're gonna get started. We're gonna watch this show cause hearing quickly, where this guy freaks out. He swears at the judge, and then I've got a new judge from Texas on the list, and then something totally different that we'll see what we get to. Okay, but it's a Court of Appeals oral arguments, so something totally different from our normal stuff, but. Oh, yes, and don't forget to select all messages. Oh, last thing I'll say before we get going. And I mean, 5 minutes is pretty good for me to have been talking that entire time. If you don't like me talking, but you like the court that I cover, feel free to like skip. That's fine too. I'm cool with that. Big D is a command in there as well, I think. But here we go. So, what was I gonna say? Now I fucking forgot. Oh, Streamlabs. Jerk sometimes. So if you're like, wow, there's a lot of stuff going on in the chat and I don't really want to deal with all that, but I would like to sort of participate with people that want to have a discussion, you can go ahead and block Streamlabs and it just sort of disappears and then you're left with like a regular chat. Okay? Oh, yeah, you got one of them. Oh, oh, I'm so glad, Les, because I'm not talking. I'm just telling people they can like we should learn how to timestamp where it's like good stuff and then the start of court. Uh, oh, I'm gonna laugh because I wrote them and I think they're so funny. Oh, okay. Okay, let's get it started. Brian's here. Okay. Happy birthday to you. Happy birthday to you. Happy actual birthday, dear Brian. Happy birthday to you. Look, I put it on the fridge so that I wouldn't forget, Brian. I even mentioned it at the top of the show. So thank you for being here, Georgia Peach. Oh, perfect. Welcome, welcome, Georgia Peach, visiting Kerman and Peach. Yes, I am sub to that channel, I think. I better make sure I am with all my profiles. You know how that works. Happy birthday to Brian. Thank you, Brian, for being here. Okay, let's get going. I probably won't sing much more. I can't guarantee anything. What a day in court it's been, my friends. What a day in court.
Have a gentleman who just popped. What is your name, please?
Christian Davenport.
Okay. And I have somebody with a dark screen that says BINAB. I just sent your request to unmute your device.
Hi, my name is Sabrina Rivera.
All right, hold on 1 second.
Let me turn some light on here.
Okay, so, all right, Ms. Rivera, I'm going to change your screen name.
Oh, I can't.
Sir, you're like in court, so you got to be quiet, all right? All right, I just changed your name. And sir, what is your name again?
Christian Davenport.
All right. Let's see. Davenport.
Hurry up, Judge. Come on. Watch what he's doing above me.
Right, this is in the matter of Nicole Marie Davenport versus Christian Robert Davenport, file number 2019-46565 TM. I do not have Holder Davenport.
We need Larry Beaver. Larry Beaver.
All right, so Mr. Davenport, we are here again on a show cause for failure to pay child support. You have a monthly charge of $411, an arrearage in excess of $4,085. We were last here on May 15th. We were present on the record for the show cause. You made your online payment. You were ordered to pay the month of June, the week prior to adjournment. The last payment we have is May 16th for 500. So, sir, did you make the June payment?
I just made a $200 payment, ma'am.
Are you smoking? Dude, you can't smoke
No,
anymore. All right,
I just made a $200 payment this morning, so I could afford it at the moment. I currently had to move, so and the reach here on this piece of paper says 3,763.
that probably has gone up, or
No,
yeah,
that
I mean, it
is-
goes up by 400.
She did say dude 100%. And he did have a cigarette in his mouth, but he did not light it, to be fair. Lucy, hi. Vaughn, hi. Who else just showed up? Oh, Karen, hello, my friends. I have to say something, guys. And this is meant to be not meant to encourage anybody to try and get out of jury duty, because we all here think that juries are integral part of the process, I would assume. However, I do believe, just knowing what I know, that if you were honest about the amount of court that you watch, if you literally were just like, I watch probably like maybe 20 plus hours of court a week, that might be your number. My number would be like, I watch 100 plus hours of court a week. They don't want us on a jury. Okay. So if you are in not wanting to be on the jury duty and you just want to be upfront, I think you could be excluded very honestly and without bad ways just because of the amount of court that you watch. Yeah, that's what I think. Oh, She's a Maker's got chicken stew cooking and cleaning in the kitchen. Woo! Love it. So, however, I think that some of us would probably be able to put our court histories aside and serve as good jurors. However, I think that you could get excluded if you wanted to, just by being upfront. Oh, and I might be vaping in my kitchen, but the guy above was sort of smoking or gonna smoke in his kitchen or in his house. So let's continue on with this one before we get to our next one. If you're new here, guys, welcome. I'm Kitchen Court Cases. This is my kitchen. We're watching court. You got to clock in for your shift by hitting that like button. Don't be a dick. Give the like a click.
Bucks every month. So, all right, so you made a payment of 200, so you still need to make a payment before the end of June, correct? So I am going to set this over to July 17th and require you to come in person.
Can I ask a question, Your Honor?
Sure.
How come I owe the less of a lot of people that you're taking to court every month, and yet I got to come in and report to you every month on a $3,000 rearage payment for child support?
So here's what I'll do. I will bring you back every single month to make sure you make payments.
So, but what I'm saying is
And then
that's
if you make every payment for like 6 months, the front of the court worker might dismiss the show cause. But if the only way I can get you to make a payment is to bring you in every single month, I will do that.
well, when I've told you guys over and over again that this is just a little insane, and I think this whole matter should be dismissed of being that
But you haven't made your payment, so I'm not
Davenport
gonna
has
dismiss
family
it.
that works for the front of the court. Miss Adams is related to Nicole and Peggy Adams. So how is
I
that
don't even know
even
who those
fair?
people are. I don't know who Peggy Adams is.
Miss Adams does.
Who's Miss Adams, my secretary?
Yes, ma'am.
Okay, well, I don't know anything about you, and unfortunately, that's part of life, but my judicial assistant has nothing to do with front of the court. So I will adjourn this to July 17th, and it'll be in person. I expect you to make the remainder of your June payment, and then at least half your July payment by then. So we'll see you back on July 17th in person. All right?
Have a good one.
Thank you.
I'm gonna have fucking
Okay, I
enough of
gotta-
this shit, man.
Well, next time I can put you in jail for contempt, so watch your mouth. All right, Sabrina. There,
Wow. Let's just roll that back one more time and listen to him just be so impulsive and unable to control his anger or feelings or whatever the hell they are, that he does this, knowing this is a person who decides this kind of shit. My lighting is so fucked up because of the time of day.
Expect you to make the remainder of your June payment and then at least half your July payment by then. So we'll see you back on July 17th in person. All right?
Have a good one.
Thank you.
I'm gonna have fucking enough of this shit, man.
Well, next time I can put you in jail for contempt, so watch your mouth. All right, Sabrina. There,
Wow, classy guy, right? Gotta love it. Okay, guys, so next we have, oh yes, the Texas judge, the new judge. Good time of day. Anyways, give me 1 second here while I go ahead and remind you that it's Brian's birthday. Thank you for reminding myself that it's Brian's birthday. I already sang once, I won't do it again, but I would like you guys to go ahead and make sure that you're clocked in for your shift. That's important around here. It is important to me, but it's mostly important to YouTube Daddy, the fickle beast that YouTube Daddy is. Anyways, hi Jerry. Hope you are well. Oh, Mayor, if you're gonna lurk, go ahead and try exclamation mark lurk and see if that that is my suggestion while I am remembering what I said we would watch. This Texas judge, that's right. Okay. Right here, just 1 moment. Here we go. Oh, this is like Judge Webster style, but not Judge Webster, by the way. If you guys are done lurking and you use exclamation mark back, I believe that does something too. I haven't done Webster yet, or Fulmer. I literally did that like 15 minutes before I started. So I got a few in. There's some good stuff, but I really don't remember what they are, to be honest. And yeah. So, oh, this is Jennifer Baker. That's who this judge is. There is a timeout feature on the lurk, by the way. Not like it times you out, but like you can't do it more than once in a little few whiles. I think I old Discord. Hi, arbitrary hubris. Judge Millhouse. Oh my god, MB. Now I can't unsee that.
0562. This is an original petition in suit affecting the parent-child relationship with an acknowledgement of paternity that was filed March 21st of 2023. All parties are on Zoom today. Mr. Warren, can you state your full name for the record, please?
Brian Craig Warren Jr.
Okay, thank you, sir. And Ms. Lewis, can you state your full name for the record, please?
Larissa Reginald Lewis.
Okay, thank you. Can you both please raise your right hands? Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
ma'am.
Okay, thank you. You may lower your hands. And counsel for the Attorney General's office.
Valerie Laskowski for the state, Your Honor.
Okay, and just, so you know, we're gonna have your hearing. Please know I'm an associate judge, so if at the end of this you don't like my ruling, you can request that the referring court in Galveston hear the case. To do that, you have to put that request in writing and file it with the district clerk's office within 3.
Okay, I'm just gonna digress one time. We'll try it as hard as we can not to. Good eye, Sashina. She is indeed driving. Also, I got married in Galveston, even though I'm Canadian. The dude does look terrified, you guys. Like, yeah. Um, Lucy, I saw it's your birthday tomorrow. I will absolutely sing for you. Happy to do it. Who else was here? Somebody else said a very nice comment. Aaron. Oh my God, you look so pretty tonight. Give me pinup girl vibes. I love it. Thank you so much. Making me so happy. I haven't checked attendance yet, guys. I really want it to be a good ratio. So if you can just go ahead and make sure you've clocked in for your shift before I check it, I won't have to be sad, okay? That would be very helpful.
Days of me signing your order. You then have to coordinate with the referring court in Galveston to get a hearing date, time, and location for your hearing to be held. You then have to provide the hearing date, time, and location information to all the parties in the case with official notice, and then you have to appear for the hearing. Also, some basic things. This is a court, even though we're all on Zoom and computers. And so please be aware we take testimony. One person will be asked questions at a time. Please don't answer or interrupt the other person. You might hear things you don't like or you disagree with. Just wait your turn and you'll get a chance to talk. Also, there's things with the AG's office that you've been speaking about probably for months now. And just please know I don't work with them. I'm not part of the AG's office. And so you might be thinking I've spoken to them about this or I've told them this, 3, 4, 5 times. Please know I only get to hear what's said during hearings on Zoom or what's in the court file. So just please be patient and answer the questions. And if you don't know, you don't know. And we'll get through with your hearing. Ms. Laskowski, can you identify yourself for the record and then you may proceed.
Valerie Laskowski for the state, Your Honor.
And you may proceed.
All right. The state is ready, or state is asking only to proceed on a temporary order basis today on the grounds of some pending criminal actions in a outlying county that involve these two parties. Okay. Ms. Lou,
Okay, this is my first time watching this lady, and this lady's a bit slow. I know that Judge Webster wouldn't like it, but apparently Judge Baker's cool with it. May MB, thank you so much. You're awesome. And I just saw Credence and Mikey. Did I see Mike coming to party? It's a Monday, and we party on Mondays, friends. Make sure that you clock in for your shift, Mikey. I cannot pay you if you don't, okay? I'm joking, guys. If you aren't already subscribed to Credence and Mikey, that would be a little strange, but they're awesome. Great place. I literally.
Oh, yeah.
I gotta jump. I better not jump too much or else that dress might come right up. Okay, let's keep going.
Lewis is asking to be appointed managing conservator with Mr. Warren appointed as possessory. We've got that's a contested matter. We've got an agreement between the two parties, but not necessarily between the state, of a standard possession order and with an exchange point and an exchange, I guess, proxy party to do that. We've got an agreement on a geographic restriction with Ms. Lewis having the right to designate the exclusive right to designate the residency of the child to Galveston and contiguous counties. an agreement on current child support of $944 monthly beginning July 1st, 2023. An agreement on cash medical support of $72.15.
$72.15.
Thank you, Jonathan. Also to Wissy, hi, thank you for being here. Like I always say, this is like a restaurant where all the chefs go after work. This is like where the creators can come hang out when they're procrastinating, making more court content for you. And I'm happy to host. Seriously, though, guys, it gets interesting in a moment here. Yes, this woman has put on her seatbelt surreptitiously while she's in court in front of a judge. Daylight. You got unsubbed from me? That's hurtful. Absolutely hurtful. In fact, seriously hurtful. That's just pure unacceptable. Anyways, let's keep going. The judge is going to note this in a moment, but yeah. Again, Judge Webster would be having none of this at all. But to each judge them their own and how they judge things, I guess. Also, $944 a month in child support. What the frick?
So, I guess. Let me correct the record, Your Honor. So the parties have agreed that Mr. Warren is going to carry health insurance through his employer at a cost of $72.50.
Okay, that makes more sense.
Um,
Miss Lewis, are you driving?
Yes, I just got off work headed to get the baby. I can pull over if need be.
Yeah, we cannot have a hearing with someone driving. It's just too dangerous,
Yes, ma'am.
and you can't concentrate on what we're doing. That you were not moving.
Wow. So I'm just gonna zip ahead here. The lawyer seems to just be like, okay, let's keep going. And the judge is like,
State would
no,
ask-
stop.
Pulling over.
The state would also ask the court to reserve both retroactive support and court costs for a final setting.
Okay.
Maybe
Yes,
any charges against Mr. Warren? Okay, what happened then? Voluntarily?
yes,
Have I accurately stated the terms of your
I always forget it's
Okay.
30 back or forward 10 back. Sorry. She parks pretty quick. I have to wonder where she was, but let's keep
we call
going.
witnesses?
Also,
the state would call Ms. Lewis when she's ready.
Yeah, we really can't proceed until she's not moving because she has to be able to
I'm
listen.
not moving anymore. I'm parked.
Okay.
So, Ms. Lewis,
Yes,
hi, Karen.
have I accurately stated the terms of your agreement that you come to today with the state and Mr. Warren?
yes,
Okay. Do you believe those terms are in the best interest of the child?
yes,
Have you entered into that agreement voluntarily?
yes.
All right. Is there any family violence between you and Mr. Warren?
It hasn't been since I left the Dallas address in September.
September of 2022?
Yes.
Okay, what happened then?
And back in September, it was the last incident that caused me to go to the police. There was some domestic violence that had been taking place for over a year in our relationship, before the baby, during my pregnancy, and after the baby. And September was the last straw, and I feel like I had no other option but to go.
To interrupt that very serious matter, but thank you so much, baby. Thank you, Mikey. Seriously, guys, Credence and Mikey, one of my favorite OG channels and great court content, and very supportive of me, which I really appreciate. So thank you so much. Oh, and Mikey, you popped my cherry.
Oh, yeah.
I'm talking about my super chat cherry, of course. But thank you.
The route that I went.
Okay. And you made a police report. What
Yes.
happened? Were
You never forget your first.
there any, did the district attorney file any charges against Mr. Warren?
So he was arrested for 2 charges. One was for sexual assault. The other was for domestic violence with impeding of the breath. They dismissed they dismissed the sexual assault case probably about 2 weeks ago, and they told me that they were moving forward with the domestic violence with impeding breath, and that it was up to the DA what the consequences were going to be, but they were going to be in contact with me to get my input on everything. On today, I actually emailed Mrs. Sellers because I want justice for what was done for me, but also my child needs his father in his life full time. And I feel like that's more important than anything. So I emailed Miss Sellers on today, Adrian Sellers, to let her know that I didn't want to, go through with the charges. And so she emailed me back saying, I just need to confirm you don't want to go further with the charges. I told her no, but she said it was still going to be up to the DA what they would do from here.
So has Mr. Warren been formally charged with any criminal act yet?
So far I don't think so. I think everything is still pending. Before today, when I talked to Adrian Sellers, she told me that they were moving forward with a domestic violence charge, but I don't believe he has been formally charged yet.
Is there any protective order in place regarding contact between you and Mr. Warren?
So there was a temporary protective order on my end placed in September. I believe it started in October and it ended in December. It was a 30-day temporary protective order and it ended in December. I've been aware that because of his case, he has restrictions that he can't contact me. So besides our protective order, he has a court order that he cannot contact me.
Are those bond
Direct.
conditions?
I'm sorry.
Are those bond conditions?
Yes, I believe so. Yes.
Pass the witness, Your Honor.
Okay, you may call your next witness.
Mr. Warren, have you been formally charged with any domestic violence regarding Ms. Lewis?
I have not.
Okay. Do you have any protective order in place regarding how you can communicate with Ms. Warren, or I'm sorry, Ms. Lewis?
I have bond conditions.
Okay, what are your bond conditions?
I cannot formally or informally speak to her directly or indirectly. I'm sorry. Speak with her or communicate with her at all. And I can't contact her family with threats or anything of that nature.
Who else's birthday was it, you guys? I know Brian's today. Lucy's on the 27th, was it? Somebody else said it. I'm going to write it down. Oh my
Do you have
God,
a
you
copy
can't
of
hear.
them?
I have the original copy, but conditions have been changed because I've been taken off of my ankle monitor. I'm off of 24-hour house arrest, and I'm actually waiting for my lawyer to update me with
Okay.
what's going on with the case. I heard something different, so I'm just waiting for him to let me know.
Okay.
Something different from what Ms. Lewis has testified to?
As far as going forth with it,
Okay.
yes. From what I understand, the first went to the grand jury with the sexual assault prosecutor, and the second one will be going doing the same thing with the domestic violence prosecutor.
Pass the witness, Your Honor.
Okay. Mr. Warren and Ms. Lewis, the state doesn't represent either of you. I'm gonna give you both the chance to say anything you might want to say. Mr. Warren, I'm sure you've spoken to your lawyer and you are aware you have criminal charges possibly pending. And so just be aware of that. I'm not asking you to necessarily divulge anything. You do have the right to plead the fifth, if you'd like. But I do want to give you the chance to say something if you'd like to. I'll start with Ms. Lewis.
No, I hate that it has come.
On that note, Daylight, that's happy belated birthday, but also I want a Peloton so bad, and one day soon, when I do get one, I'll go on a ride with you, okay? Uh, anyways, you might have seen my face just like went weird earlier. Surprised. Nana's watching a show so loud that, and the person was swearing. I thought we had a court swearing thing that I missed somehow earlier. No, it's Nana's shit. Okay, let's keep going. Oh, I would do rides with you guys every day. Gotta love to ride.
To this day. Other than that, no, I don't.
Okay. And Mr. Warren,
As far as my son Easton, I there's nothing more that I want to do than take care of him. I've been trying to have a list because of the conditions. I've been trying to have a list or update of sizes of clothes, shoes.
do the conditions affect the children too?
No, it doesn't, but it's been pretty difficult for my family to get Easton because of Miss Lewis. So we have not been able to get clear in clear contact about what he needs. I know he needs things weekly, but I just haven't been able. I can't get him milk if I don't know the type of milk or the size of the Pampers. I haven't seen before this weekend. I haven't seen my son since January 2nd, and my family has been trying. My family hasn't been able to see him either. So it's just been personal restrictions from Miss Lewis causing me not to be able to.
1 second, we lost Miss Lewis, so please, let's wait and see if she comes back.
What a perfect opportunity for me to talk while they wait for her to come back. Bitches Against Bullshit has raised a very good point. First of all, we don't advertise it that much, but there is a self-exclusion program that you yourself can enter to avoid gambling in this chat room. Just contact me and I will self-exclude you from it. Other than that, I think it's probably not as unhealthy as some forms of gambling. I haven't broken any knees yet. MB plays soccer every week in a league That's awesome. I want to get back to playing soccer. I used to play soccer all the time, but I was riding my sister's Bowflex bike for a while to Peloton like rides, but she got rid of that. So, because she never used it. I'm like, well, I fucking use it all the time. But anyways, oh, they're still not even they're like I was like, shut up. But this time they're taking their time. Sashina's saying, I feed my sheep every day. Oh, also, there's like 68 people of here or that are here right now. If there's one more, that'd be great. But also, just clock in for your shift, hit that like button, subscribe.
Okay, I'm not sure we can hear you very well.
Can you hear me now?
Much better. Yeah.
Okay.
Okay, sorry. You can continue, sir. She's back.
Yes, there was just personal restrictions from Ms. Lewis to where we weren't able to get Easton or have clear communication about what he needs. And the question has been in the air since I'll say October or November. And she's cut off my family multiple times since. So we haven't.
Do I have?
One moment. Sir, so what are you asking for today?
I'm asking that I have a chance to, I'm not sure if this is even proper, but I'm asking if I have a chance to, now that I'm off of house arrest and everything, I'm able to move around, actually go get stuff. And she, within the last 3 weeks, she has been compliant with giving us sizes and everything. And the type of food he needs. I would just like the chance to do that or change the settlement. I'm sorry, I'm not really sure how this goes. I haven't had the chance to do what I'm supposed to do as a father.
Miss Lewis, do you have something you want to say? I'm a little confused.
Yes, I have a lot. I never knew about the court order that he couldn't reach out to my family because there was a time he was reaching out to my family a lot. So between January and now, if he needed to see if Easton needed anything, he had plenty of opportunities. He had grandma, he had cousins, he had my mom doesn't talk to him because of how nasty he talks to her, but he had other outside. And the reason why there was communication cut off with his family because there was threats made of my child being taken away from me. There was CPS called on me after my child got back from them. So my therapist and everyone around me just told me as of right now to cut all communication because it was just too much chaotic drama for no.
I'm not sure if a therapist would have said quite that. Maybe. But, don't break court orders. I don't know if they had a court order already established. I guess they don't. This is establishing parentage. Oh, I'm so used to Judge Webster like whipping through things and we're like getting to the bottom of everything that I'm confused. Um, and as usual, yes, the children are the ones that pay in these situations. So, um, you know, yeah, that's a problem. But 944 is a ton of child support. Hi, Hayden. Um, and welcome everybody who's here, who just came in. Make sure you clock in for your shift, please. I'm gonna check right now. I want that ratio good.
Reason that was going on.
And
so yes,
I have a question. So you're in Galveston County. I'm guessing Miss Lewis, because that's where this case got filed. Okay.
Yes.
So are you in Galveston County or are you up in Dallas?
In Dallas County.
Okay.
So that's another reason why I reached out to Adrian Sellers because I feel like me and his communication could be where it needs to be for our child. When other people are involved, like his side of the family, it's it's already pre-established drama before the child was even brought into the world. So now that the child is brought into the world and I did what I had to do for the safety of me and my child, there's been a lot of backlash. And to not have to deal with that, I just cut all communication. But like I've stated before, he's had other outlets to reach out to do what if he wanted to do something for Easton. The only reason I went through with the child support is because he hadn't reached out. It's all been on me, which I'm a mother. I'm going to take full responsibility regardless. I'm going to do what I have to do. I work 2 jobs. That's not what the plan was, but I have to do what I have to do to make sure that my child has everything he needs and he wants. For the simple fact that we can't talk, that's the middleman is not a good middleman. But this past weekend, I was, I put all my feelings to the side. I allowed his mother to come and get him for the weekend. And, to me, I feel like the only reason he has or they have reached out is because he got served a note, because I hadn't heard anything from him or his side of the family until Father's Day weekend. And he got served with the child support papers on the 5th.
Okay. There's a lot of issues in your case. And it is 4:30, so I don't know that we have enough time to fully hash everything out this afternoon.
I don't know that it's appropriate for a final order or any orders regarding conservatorship if we're dealing with bond conditions and
Well, clearly she'd be sole. I mean, there's no way I could be someone who can't communicate joint.
I have a question.
Yes.
Is there any way I will be able to present proof? Because I have proof of everything she said, or countering everything she said.
Okay. Let me just start by saying, at the end of the day, what the Attorney General's office pled for is determining conservatorship, which is who makes decisions regarding your child, visitation issues, non-disclosure, whether personal information is in the order, child support, medical support, and back child support. I can't go back in time and fix whether people communicated about the size of clothing. It's almost, I mean, I hate to say it's completely irrelevant because it's reflective of other things going on. But it's not something I'm going to decide on. That being said, that's why I was trying to figure out what you're asking for today in terms of the things that are before me, and what you're asking for. It sounds like the state, when they began with, said that whether or not she'd be the managing conservator was contested. Was that contested by Ms. Lewis or by Mr. Warren? Ms. Laskowski?
Mr. Warren.
So you want to be a joint managing conservator right now, sir?
Yes, I do.
Okay. In light of all that's going on, joint managing conservatorship means working together for the child. And I'm not saying you all can't get there, but with a bond condition that says you can't talk, I just can't really do that.
I just need to address something really quick that was brought up in the chat here. Al, the reality is that I ran out of money to keep paying actors to do these court things for me, so I actually had to go with real court. But yeah, this one's real. This one's real. You can't write this.
And at this time,
Can we will we be able to revisit this? Because the
and that's
bond-
where Ms. Laskowski suggested a temporary order at the beginning of this. And what that would do, it would put some stuff in place. And that's what I'm trying to figure out how much in place. And then we would come back and everything really can be revisited on temporary, or when you do a temporary order, it's technically all on the table, depending on what circumstances and things change over time. So it sounds like you all agree about the child support. Yeah, I'm not sure why so did you ever live in the Galveston County
Yes.
area?
Yes, ma'am. That's where my family is.
Okay, so your family's out here, you're just up in Dallas.
Yes, we'll work.
And that's why you were all agreeing to, and ma'am, do you plan on leaving the Galveston area?
No time soon. I'm waiting until I finish school and the baby is old enough to leave. So that's why I said right now the Galveston and Houston area was our limits.
Okay. So it sounds like you all have an agreement on child support. Insurance will be through your job. Managing conservator, possessory conservator with, I guess, a Harris County and contiguous, because that's a little bit bigger. It includes Galveston, but it gives you some of the other more northern sides, which are closer to Dallas anyway. And then I guess Mr. Skowski thought you all had an agreement on visitation.
So no, we do. I agreed to the first, third, and fifth of every week of the weekend. She said the first, third, and fifth of weekends, and then she said we split holidays, the Christmas and Father's Day and
How would you
birthday.
do exchanges and things?
So I agreed that that the mother, I gave her Miss Carol's name. I agree that I am okay with dropping off to mother at my aunt's house. I also gave the address of that drop off location, just like we did this past weekend. It was the first weekend since
Did
January.
the baby stay at the aunt or mother's house, or did the baby then stay with Mr. Warren?
I believe baby stayed with grandmother. I told them that when we first had an agreement, I wanted updates because that's how I do with my grandmother, with my mother. I call every hour on the hour just to check on my child. Apparently that was, a bit much for them. So this time I told her that, I didn't need the most frequent updates. I know he's in good hands. And so I honestly don't know if he stayed there this weekend. I just know he was okay, well taken care of, and returned back to me on Sunday.
So they had the child from what day to Sunday?
They had him from Friday. They picked him up from day.
Yeah, I believe she just said that she wants to call every hour, and her phone company mercifully disconnected her service upon hearing that. That's the only explanation of why she would be wanting to call every. No, I'm just joking. She's obviously creed framed or frozen at the moment, and they're just literally nobody's saying a word about this. I haven't muted it. Nothing. 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 Nobody's acknowledging this. This kind of shit messes me up when I'm like reviewing videos and I'm like, do they all freeze? Am I frozen? Is this life? Also, if you're just getting here or you're new here, I'm Kitchen Court Cases. We're watching Court in my kitchen. Don't be a dick. Give the like a click. That's really helpful.
Okay. So they picked up.
I couldn't take off today, so that's why I'm doing this through my phone and in the car.
That's okay. So they picked the child up Friday and returned Sunday evening.
Yes.
That sounds reasonable.
And so you don't know if the baby stayed in Houston, in the Galveston, Houston area, or went to Dallas?
No.
Okay. Mr. Warren?
I travel on the weekends. I'm off every weekend. I work Monday through Friday. And I travel home. I've been traveling home for the last 2 weekends, and I'll be back every weekend I can to see my son. So
Okay. So you come down here and you stay with your
My
mom or your aunt, I guess?
my mother, yes.
Okay.
I do not go to meetups.
Okay. And the state had no proposal on visitation.
The only proposal was, standard possession order with an exchange at 2435th Avenue North, Texas City. That is, Ms. Lewis's aunt's resident, and Mr. Warren's mom would be doing the exchange. So that's cool.
Okay. What I'm leaning towards ordering, and this is not something I would normally do because I find it hard to order supervised visits with overnights, but your situation is unique, as they all are. And so given that he comes here and stays with relatives, I think it could work. I don't want to jump to a straight standard possession order because that's like large chunks during the summer, weeks at a time, and I just don't think that's appropriate right now with all that's going on. But I do think it's real important, and it seems like you all think it's important that the baby gets to see Mr. Warren, and maintain a relationship. So what I'm kind of leaning towards is maybe the first, third, and fifth weekends. I guess you seem happy with Friday to Sunday. Is it six, like after daycare, and is it a 6 o'clock drop off on Sunday or? Five, three.
This Sunday was a 2 because they
2.
had an obligation. Yeah.
Okay, so I guess it's around 5 o'clock Friday. Is that like when daycare ends, or 3, 4?
Yeah. The latest for daycare is 6:30. I'm usually there around 4:30 because I get off at 4. So yeah.
So they can pick up from daycare.
Yes, the mother has
She's
I
on
put her on
the
the
list.
list.
Okay.
Yes.
So pick up from daycare through Sunday at 3.
That's perfect.
And then his mother would do the pickup and return. Mother or aunt, I guess, would do pickup and return.
Yes.
Okay. And then supervise the baby. Either mother or aunt will be with him in the residence. I mean, it doesn't have to be hovering over them, but in the residence at all times and in the vicinity, I guess. I'm not sure how to word that exactly.
Me,
Yes. Yeah. And this is just for temporary order. This is just to make sure you start having some regular visits
yes, ma'am.
until we see where everything filters out.
Yes, ma'am.
I guess shall be supervised by mother or aunt, and you know the names, right, Ms. Laskowski, at all times.
Yes, Your Honor.
Visits, okay. And so that covers visits, conservatorship, child support, and then we'll reserve the other issues. And Ms. Laskowski, when were you thinking of coming back?
Okay. I would say maybe October, maybe even late October.
Yeah. I don't think that's a bad idea.
Especially if we're looking at finding out more information about the wheels of the criminal justice situation for Mr. Warren.
Yeah.
I mean, we could do
Wheels of criminal justice.
10/16, 10/30. I mean, October's pretty wide open, except for those first 2 dockets are conflict and enforcements.
Yeah. Why don't we, let's say either the 25th or the 30th. Do either of you have, a preference for a Monday or a Wednesday?
I have no preference.
Let's do October 25th.
I have one question about, do I have restrictions on where traveling? Like, for instance, for his first birthday, we're going out of the state. Is there any?
That doesn't really sound like you're asking a lot of permission right there. Her story is a little sus to me. Anyways, let's see what the judge says. After this, we have that. Well, we have one other video court clip before we watch that oral argument. So you know how everybody loves a good oral argument.
Restrictions to that.
There's no restrictions on you, ma'am.
Okay.
The residency restrictions only like moving, so like you couldn't move to a
Okay.
farm. But yeah, you can take your child on vacations or visits or, you know, trips.
Great.
Yeah.
And what about a non-disclosure on the temporary order, Your Honor?
Yes, and non-disclosure, as I don't know that it accomplishes anything, but we'll do a non-disclosure.
I understand.
I have a question.
Yes,
Is this off of net or gross income?
it should be off of net. Ms. Laskowski, was it calculated off of net?
Earlier
Yes.
I was told gross, so I'll just making sure.
We start with gross and work from there. So we take your gross, we deduct taxes, deduct cash medical, and then that leaves us with your net. The guideline percentage comes off your net. So we need to know all of that information. So that's why you heard both.
This is me taking the thumbnail shot. Come on. Oh my gosh, this is
Okay,
way
so we did
slower than Judge
October
Schwartz.
25th, is that what we agreed to?
Yes, Your Honor.
I'm never gonna remember October 25th. Yeah, right.
So the Attorney General's office is going to draft up the temporary order based on the agreements and ruling today. And then we'll all reconvene. It's gonna be the same Zoom code for that October 25th date, and we'll see what's going on with everything at that time.
Okay.
Thank you.
Thank you. So if
So,
Mhm.
so if y'all will return to your breakout rooms, I'm gonna go draft this order and send it out to the two of you by DocuSign in a few minutes, okay?
She came back in, so let me move her to a new breakout room.
Okay.
You should see a pop-up, ma'am, and sir, if you click on your screen, there should be an icon with like a square with 4 squares.
Okay, well, that was interesting. Definitely not exactly how I'm used to seeing them handled, but indeed a method of doing it. Give me one moment here as I prep up our next clip of the day. If you're new here, I'd love to hear what you had for dinner. We didn't really hear that many dinner things, and I want to hear some dinner things. Let me just pull that curtain down for 1 second. Bluebell's still here, as you can see, and she has had just a tough day being, a Labernese dog with not a care in the world. So the next clip that we're gonna watch is yet another one that
no
I
one was
found today.
physically
Hold
injured.
on, Judge, I'm not ready. And honestly, I'm just going to be totally upfront. Titwissy, I saw you in there after I had made the video. Like, you commented, I guess, and then I was making the video, and then I was like, oh. But the guy's look definitely got me to make this video to start with. So I come by it honestly. Sometimes when I'm just zooming through courts, I catch the eye of what you're about to see, and you'll see why. I just had to record.
Okay, DDC, I'm back.
Say your full name.
Mark Lukai. Thank you, sir. Mr. Lukai, you've got a number of traffic matters where you have failed to show up when you missed those court dates. A judge issued an arrest warrant for you. As to these matters, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. Do you understand those rights, sir?
Yes, I do.
All right, so first ticket is P1223829. Charge of driving while license suspended, no insurance misdemeanor, and driving an unregistered vehicle. Ticket P1303629, driving while license not valid. Ticket P1309728, driving while license not valid, drive unregistered vehicle, and no insurance misdemeanor. Ticket P1355587, drove while license not valid, driving unregistered vehicle, no insurance misdemeanor. And ticket P1396018, entering a vacant dwelling without owner's permission. Sir, these are all misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or a $500 fine. I'm going to set aside the arrest warrants, enter not guilty pleas on your behalf, and give you a personal bond. Your next court date for these will be July 25 for a pretrial in front of Judge Perkins. Now for your more significant matter. This is case 23057560, State of Michigan versus Mark Lukai, counsels.
Judge Matthews, that's for the people, P71917.
That's my friend, bro. We have Mark Lukai, like
Court will enter a not guilty plea on your client's behalf as to bond.
Thanks, Judge. Here, the people are going to be asking for a $5,000 10% cash surety bond as well. Your Honor, we would be asking for a no driving restriction. Your Honor, just a couple of housekeeping matters that have second notice that's on the complaint. It actually was for the defendant pleading guilty of 3 attempts of controlled substances, only says 1 judge. As well, that was an 18 offense. Actually, the probation didn't end up clearing up until I believe it was the middle of 22 because of multiple probation violations, Judge, which actually it should have ended about 1.5 years prior to when it actually ended. In this particular instance, Judge, I'm sure you had the opportunity to read the investigative report. The defendant breaks out the complainant's window of his vehicle, damages the ignition, manually jumps it, takes off, and then the police end up finding the defendant in the stolen vehicle at a gas station while he was pumping gas into the car that he allegedly converted into his own. Your Honor, here, on top of the fact, and Judge, you just went over this, the defendant wasn't even driving with a valid license at the time. He had multiple caviuses, and now he's brazen enough to go and take the vehicle, drive it around, and put gas in it like it's his. Judge, this is, I think that people would argue, assaultive in nature. They would also like to argue the fact that if the defendant, knowing that he can't be on the road, is willing to do something like this to another person's vehicle, steal it, take it, and then act like it's his, this defendant is a danger, Judge, and the people do feel justified in asking for that now.
Thank you. Thank you.
Yes, Your Honor. My client does have a habitual second, which is non-assaultive, just like this matter. There's nothing assaultive about this matter. No one was injured. No one was injured.
Physically.
Yes, ma'am. Lifelong resident, lives with his brother, father, and nephew. Indicates to us that he does his report as a contractor. His employment varies. He makes low than 200% property guidelines. He does suffer from mental health and some physical conditions in which he takes 13 medications, which he needs. This is a non-assault allegation. My client's not on probation anymore. And respectfully, we're gonna ask this court for a personal bond.
Thank you, counsel. I guess I've got an evolving thought on this, in this rush to adopt bond reform. I think somewhere there's been some conflation of non-assaultive and victimless. Someone went out and bought a car and they go to work every day, pay for their car. And then other people allegedly decide, oh, I'd like that car. Steal it. So here's what we'll do. Mr. Lukai, while this case is pending, you are not to drive without a valid license. Is that clear, sir? You said he does construction work, or what?
Yeah, he's a contractor.
Contractor. But he's not working on a regular basis. Is that the gist of?
He's employed, I mean, because that company, but it's always 200% profit.
I work every day, sir, Monday through Saturday.
Thank you, sir. Court's going to set bond this matter at 15,000, 10%. Staff Ford Warner Court of Account.
Thank you,
There was a bond
Donna.
redetermination hearing Wednesday, June 28th. Further dates will be July 5, probable cause conference, July 11th, preliminary exam, both in front of Judge Sabri here in 36th District Court. Thank you, sir. You can step aside. Sure, go ahead. Go ahead.
I do understand your concern, and I understand your arguments about victims assault. I think there's a big difference between being invasion on somebody's privacy or invasion on somebody's things and assault behavior.
There is. That's why I didn't make it cash certain.
Right, but this nothing.
When I could get a personal so I could work.
There's nothing to tell us that he's gonna run from this situation. He didn't have any conflict with the police in this matter by getting arrested. That's why I'm just asking you to reconsider that, at least, even if it's personal bond with GPS shut.
I work for the
about what he's doing. I had things stolen from me before. I had people come to my house and take things. And I've been here, and then I've been had assault behavior happen to me where I've been held at gunpoint as a kid when somebody came to my house. So I do know the baseness of these actions. Even though there's still innocent that proven beyond reasonable doubt. So I do understand your argument.
Dollar store Nick Cage. Oh, that's funny. He does look bored, and he looks like his tattoos were put on like upside down, or like, like the lick on ones.
At this point, my client it's a thing. It's an application process. Which I'm not saying. It's very invasive on somebody and it leaves an impression on them. I'm not taking that away.
Thanks, Daylight.
He didn't attempt to injure anybody. This wasn't an attempt to injure anybody. He's not a threat to. He's not showing that he's a threat to the community or a threat to anybody. And even his past convictions don't show that he's a threat to anybody. His past convictions are all non-assault. You know what I mean? So it's not showing that he's a threat to the community. It's not showing that he's a threat to anybody personally when it comes to their body. When it comes to their body, and it's not showing that he's a flight risk. He didn't run and take off from the police out there. He didn't put up a fight and a slaughter exhibit.
You know, it's, counsel, I appreciate your arguments, I do. But it's crimes of this nature that bring down the value of a community. People either have to pay higher insurance premiums, or they don't want to live in Detroit, or any number of things that lower the overall value of the community. And so while we're, sometimes quick to say, oh, no one was physically injured, it does not mean that the community as a whole is not injured by the alleged actions of this gentleman. Moreover, as I've already indicated, there's at least one person who was going to work every day, buying his car, and he comes out one day and his car is gone. And so I think part of what this court's role is in protecting the community is to prevent, to the extent we can, actions such as those alleged here. So I'm comfortable with the bond that's set. Yeah.
I had something.
You're all set, sir. You can step aside.
Wow. Like I said, that was Kitchen from the Past. That was what I caught this morning in where I don't even know where that is to Wissy. Is that's in see, like I said, I'm you know how I am. I just see and like court and record it. But oh, hi Bluebell, you're back in. Yes, did you guys see my do you know how long it took me to do that? Is that 36th District Court? Are they all the 36th District Court? This is the 36th District Court. I'm just kidding. But if you type in Bryant right now as a command, you may see something like that. Okay. Next, we're going to something, like I said, that is different, but I think that you guys will enjoy. Let me just... Can you, like, slow down and not, like, choke, please? God. Hi, Basement Gardener. I hope you're doing well. So many of my favorite people tonight. Are you like what are you coughing weird about? Okay, that's what I'm grabbing right now. Okay, so I saw some really, really yummy food that people were having in the chat for dinner. Thank you for sharing that with us. I really appreciate it. Basement Gardener, what did you have for dinner tonight? Do you care to share? And Taslet auditors laugh like hell. Do you eat anything other than auditor tears? I'm just joking. What is this? I titled it wrong to begin with. Oh, thank you. And then I fixed it halfway through. So, like I said, this is going to be something completely different than what we normally look at, but that's sort of the nature of a live show over here on this channel. We look at a bunch of different things, and that's just the way it is. It's what I want to see. So, what we have here is... Okay. 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 Let's just restart. Basement Gardener had breakfast for dinner, 2 poached with a ham and English muffins. That's awesome. Oh, Shane made chicken franchise Tom. I'm not sure what that is. Maybe that's something I should know, but I'm Canadian and I don't. Okay. So, like I was saying, this is from something that we're not normally let me just see how this looks. Okay, now I have to fix that. It's from appeal courts, and it's the oral argument part of the appeal court in Ohio, which is actually not a court that I've done in long or ever, I don't think. And so that's part of why I was really interested in it. So, but you're going to notice that this is a very different type of hearing than what we normally listen to. And in fact, I'm not really sure if you guys will like it or not. I'm not even sure I'm going to like it or not. But I'm willing to give it a try, and I hope you are too. While I'm getting this sorted out, if you could do me a solid favor and go ahead and clock in for your shifts, that like button. We've got so many new subs lately. I'm so excited to have so many amazing subs. Seriously, it is awesome. Elaine's, am I saying your name right? Had Miss and Taddy tonight needed a good hearty meal, a half a week of bread.
Oh, yeah.
Thank you so much for the £4.99 that I need. I've got to get off screen while this gets playing until we get going, okay? But thank you so much.
What's up, guys? Welcome back to Kitchen Court Cases, where we watch court in my kitchen. Today, we have something a little bit different than what normally we show, but I really think that you guys will enjoy it. It is a Ohio Court of Appeals oral argument about a CPS case, and I'd love to hear what you think about it. So, let's get going.
All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Candace Cobb presiding, is now in session. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeal, in Re EM. For appellant?
Your Honor, Monica Welker for Mother Robin Mage.
Thank you.
May it please support Alex Vanderzee for Father Lee Collier.
Thank you. The next case of
May it please the court, Monica Welker on behalf of the appellant, Robin Mage. Your Honors, this is essentially about the length of time it took the trial court, Hamilton Juvenile, to decide a case regarding a toddler. This case took 4 years to get from initial filing to determining of an objection. The objection actually only took about 9 months. The vast majority of that case was at the trial level. One of the many causes of the length of time was COVID, but we also should not allow COVID to affect the life of the child.
And I've been, I've been concerned about some of the delays, particularly in parental termination cases. But I read your brief and I don't see any authority for the proposition that you're arguing. So what is your best authority to say this is an error that warrants reversal?
Understood, Your Honor. I think the best authority is the best interest of the child itself found in 310904. It's not in the child's best interest to have decisions made for it that are 4 years old when the child is aged 4 years. Civil cases are not like criminal cases, as you know, of course, where there's a definite right to have your case heard within a certain amount of time. And obviously, juvenile court, due to the sensitive nature of its work, has sort of its own, it's given lots of leeway when it comes to some of the decisions they have to make because they have to do what's best for the child. However, in this case, the length of time it took was definitely unjust. I don't believe there's a strong source in favor of a time limit because of the sensitive nature of cases. However, in this case, it obviously took too long.
Well, how much? So you said that 9 months of the 4 years was litigating the objections, right? Is that what you just said?
Yes, there were several continuances, several needs to push things back, etc.
Okay. So what amount of time was just due to the COVID delay out of those 4 years? Because there were continuances by your client requested, correct?
Yes, Your Honor.
Okay.
The case was, the main effect of COVID on the case was from March to June or July of 2020. That was when the courts weren't open as much. That was when, basically, unless it was an emergency in Hamilton County, it was hard to get in front of a magistrate or a judge.
So March 2020 to July 2020?
I would say yes.
The COVID delay?
Yes.
Okay.
After that time, the courts were hearing cases, just everyone had to be masked up, behind glass, et cetera, et cetera. So the fact that the most important thing I think when we talk about the delay is the staleness of the evidence in this case. The GAL in this case looked at a toddler, and by the time this case was done, this child was school-aged.
So your issue is not as much the delay as the fact that the delay caused the evidence to be stale.
Correct, Your Honor. I think we have to appreciate, sometimes cases will take a long time, but as long as the court's looking at the child as it is, as close to the day of the decision as it can, as opposed to the day of filing, and because of the nature of children, I think the court has to do that. Unlike other cases where it goes by what things, the status quo is the day of filing. When it comes to children, that's why we appoint guardians ad litem, was so that they can keep abreast of the child's needs and the child's wants. In this case, there was a long period of time, and as far as we can tell, there was actually only one visit by the guardian ad litem to the child and had been years prior.
Did mother ask for the guardian ad litem to do a second visit?
Yes, but I do not believe we have written documentation of that. I think it may have been oral.
Is it on the record?
No, it would have been private channels.
Okay. I mean, that could have been done, right? A request saying, look, Judge, we've had this COVID delay, the evidence is stale, we would request another evaluation, another visit so that we can get more up-to-date evidence before we start proceedings.
Yes, Your Honor, that could have happened. I wasn't the trial attorney, so I can't explain exactly what happened there, except to say that Mom definitely wanted that to happen. It did not happen.
Well, in related vein, were there any objections to the delay that mother raised at any point? Did she jump up and down and say, look, this is taking too long, I want my hearing now?
I believe mother's objection covered, was one of the many things mother's objection was about, I believe, was time.
No, I mean during the proceedings. I'm not talking about the objection to the magistrate's ruling, but like during the course of this nearly 4 years, at any point in time, did mother kind of tell the court, this is taking too long, this is ridiculous, we need this heard now?
On the record, you'll find it in the appellant's trial attorney's question.
I'm sorry, but what if she did? That doesn't usually go over very well. I'm probably cracking up. I'm gonna shut up. But when parents freak out in CPS cases, it doesn't look good on them.
She discusses how long it had been since she's seen them. I think it's the closest she'll get. You know, the mother did not file any formal objections with the court except for her final objection to the magistrate's decision.
Well, I think that's the problem in these cases out of juvenile court, because a lot of times what happens, at least from what I see on the transcripts, is you've got multiple parties often, you've got GAL involved, and then they all sit around and say, well, I can't do it on this date, I can't do it on this date, and then the next thing you know, the next hearing is like 6 months out. Well, from my perspective, that looks ridiculously long, but those are the lawyers making those determinations and no one's objecting to it. So, I mean, that kind of puts us in a bind when you come to us and say, like, it's taken too long.
I understand, Your Honor. I think if we were doing, if they had done a two-front thing, which is kind of what we did in our appellate brief, it's taking too long and the evidence is stale. If we know things are going to take too long, so long, then it's up to the parties involved, especially in this case the GAL, to update their information, make sure they're correct. I mean, for example, breastfeeding was discussed in the decision. The child had been breastfed at this point for quite some time.
It was discussed, but was it really what the court relied on in making its decision?
The court's decision focused on the attachment between mother and child. They felt it was, for lack of a better term, unhealthy. And that was one of the two things they pointed to, three things they pointed to. They pointed to breastfeeding, they pointed to co-sleeping, and they pointed to the reaction the GAL saw one time when the child was at a transfer between the parents and did not react well. And appeared to be afraid, and mom had to carry the child to the car.
I'm looking at the.
Actually, basement, it's just my boobs are uneven. My top is uneven, but my boobs are actually uneven, so they'll never be exactly the same. Thanks to breastfeeding, as I mentioned, breastfeeding, I breastfed my daughter for like 2.5 years, and at like, oh gosh, a year into breastfeeding, she went and decided that she only wanted one boob. So for like a year and a half, I only breastfed her off. And what was I also gonna say? Oh, we also co-slept. So this is like what they're saying is the kind of stuff that I was as a parent. It's hard to feel bad for them. And thank you guys. I love this out.
Best interest analysis, and it doesn't seem to focus on the co-sleeping and or the breastfeeding, but more the distrust your client has for the father. In addition, there have been several allegations, unsubstantiated allegations of sexual abuse, and it notes that the mother now admits that that did not occur. I think there were 3 instances of that. And can you address that, ma'am?
Sure, Your Honor. In this case, obviously, the parties are no longer together, so obviously there's going to be some distrust. Allegations are not uncommon in these kind of cases. Because of the length of the case, however, it's hard to say if one party felt that way at one point and then down the road they may have changed their mind. Mother was asked during the trial about that.
Those are fairly serious allegations.
I'm sorry, Your Honor.
Those are fairly serious. Those are criminal allegations. They're fairly serious. And
Yes,
I think the court,
yes, they are, Your Honor.
and so it seems like the court looked at that as well.
Yeah, absolutely, Your Honor. Those are serious allegations, and if a mother or father truly believes those allegations, they have to speak up about them, and they have to have them investigated.
Arbitrary hubris. I'm laughing so much at your comments. It's like I'm playing Ohio Supreme Court, and I'm barely talking. I'm just standing here. It's not my fault.
My understanding is these were investigated and there was no hard evidence provided of it. However, because Mom raised these questions at one point, it shouldn't be held against her because, she wasn't making these up whole cloth. She had concerns. And when a parent has concerns about these things, we would condemn them if they didn't bring them up and investigate them as they could. So we would hope the court would at least give this case, for lack of a better term, a do-over. A chance to have this case relooked at again with fresh evidence and to see that where the parties are at the time of the decision as opposed to where the parties are the day of filing. Okay, thank you.
Thank you.
Now I think we have the dad's lawyer. Or maybe the mom's. I don't know. She'll introduce herself. But she's nervous, guys. So be gentle.
Alex Vanderzee for Father Lee Colliver. And admittedly, this is my first time in front of you, so I'm a little nervous. I'll be addressing some of what Mother's Counsel had brought up. First of all, the time issue. The time had never been an issue until very recently. Importantly, it has, as you all had already discussed with counsel, it had never been objected to. Mother actually requested 2 of those continuances, and Father never requested any. I've been his attorney since 2018, and he had wanted this done as speedily as possible, most efficiently as possible, and the right way, of course. But he never wanted to have any kind of continuances. So I just find it.
So Father never requested any continuances?
Not that I can recall, and not that I have seen in my review of any record.
Well, and so back to my question to opposing counsel, like, did anyone object to the length of time this was taking? As best you
Not
understand?
officially on the record. I mean, of course, my client was frustrated with how long it was taking, but never anything.
I mean, no one's objecting to the court and saying this is taking time.
No, Your Honor, no. I think it was understood because so much of this happened during COVID, and it was a world that none of us had lived in. The magistrate herself at the beginning, it was Magistrate Kelly, who was saying, our docket is too filled up, or whatever her reasons were, and we did not formally object to anything. And I think notably, Mother didn't either, because she really had the advantage while all of this was pending. She had the time schedule she wanted. She had the child in her home. She was able to conduct her life the way she wanted to. So I don't believe that the time factor is actually a genuine concern for Mother.
So what is someone supposed to do that is in this situation and it's taking, way too long? Like, what are their realistic options for relief?
I think that's an excellent question, and I don't think I have a good answer for that. I only practice family law, and I'm in 800 Broadway pretty much every day of my life, and I'm one of those attorneys when you say no to the day, no to the calendar, and I'm sure you see all that in all your transcripts because there's just not enough time on the docket, and we're all very busy, and we can tell our clients, if you'd like somebody who's less busy or you want a different court, go move somewhere else for 6 months and try there, but it's not realistic in our court the way that it is set up right now.
And the court docket backlog, it takes a long time to get on the calendar anyway. And then to be able to coordinate everybody's schedules seems very difficult.
Yes, and our court was backed up before COVID, and then that certainly made it, worse. My client was ready to proceed at trial every day we were there. Notably, there were several allegations that were eventually unsubstantiated sex abuse allegations. This was a huge theme of this case. Mom, I don't know if they were genuine or fabricated, but she made several allegations, many allegations of sex abuse by my client against the child. All of them were unsubstantiated, and all of them could have potentially caused harm between my client and her child. It wasn't just one, and notably, she made an allegation to Mayerson after this court even told her not to. The trial court specifically said, you'll make no more allegations of sex abuse, and she did anyway. I think that is important for this court to note. There was much made about breastfeeding and co-sleeping, and as I think the court already asked some questions to opposing counsel about this, it really wasn't a substantial issue. It wasn't that this mom had decided to breastfeed longer than usual or co-sleep with her child. That wasn't the issue. It was that she was using it to then say, the child can't go spend the night at Dad's house or is too afraid to be away from me, and it wasn't genuine. That's always been my client's thought of that.
But at the same time, the argument is that by the time this case was tried, she was no longer breastfeeding. She was no longer co-sleeping. So even relying on, what you just said seems to be relying on stale evidence.
I don't believe that evidence is stale. Especially in juvenile court, kids are growing every day. And the guardian ad litem and the court has to look at the evidence that's presented to it at that time. And at that time, that was something that had
Right,
been
but this
very
gets back into the delay question and the issue that I've struggled with before in these type of cases where because, the hearing might take place over an 8-month period, by the time the last testimony is taken, it's still on a look back to the beginning of the case unless there's been some new investigation. And then that kid has, as you said, evolved over that period of time. But how are we supposed to reconcile that?
Well, I think it's important to also note that our guardian ad litem had been there the whole time. So counsel notes that the GAL had been to one visit, but that didn't mean she stopped her investigation. She had continued to be in contact with mom and dad and counsel, come to court proceedings, and knew the trajectory and the counseling and the schooling and everything that was going on with this child, and still believed it was in this child's best interest to be with her father.
But I'm trying to understand, you said that Mother was using the breastfeeding and the co-sleeping as an excuse to not allow the child, to say that the child couldn't visit with Dad? Is that what you said?
That was partially it, yes.
But then she stopped breastfeeding and she stopped co-sleeping. So that was not an excuse that she had at the time of the trial. So how is that even relevant, the breastfeeding and the co-sleeping, to the visitation with dad?
I think it's something that's notable, but not something that was heavily weighed in the ultimate determination here.
So what was heavily weighed in the ultimate determination here?
I think quite heavily was the consistent allegations that were unsubstantiated of sex abuse.
And before the hearing, when was the last allegation, how much earlier was the last allegation of sex abuse? I'm just trying to understand.
And I'm trying to remember,
Yeah, because she said she stopped believing that as well and stopped doing that.
She did say that, yes.
And I'm just kind of curious as how long of a gap we had.
I don't think, to an official police officer or Mayerson or JFS, I don't know exactly how long, but Mother maintained the day we walked into our last hearing that there was sex abuse going on. It wasn't until I feel that the evidence was so heavy that there was nothing going on that she changed her story because it was really starting to seem outlandish. And I think that was the first time that she really thought, okay, no one believes me. I'm going to change my story.
But that was the major thing that the court, in your opinion, relied on in deciding this custody dispute was what the court, I guess, believed were they were unsubstantiated allegations of sex abuse.
And how often they were occurring and how serious they were. These, I mean, not to put sexual abuse on a scale, but this was tantamount to raping this child. Oral sex being performed on this child by her father, which didn't happen. And that's a huge factor, I believe, in that the trial court took into consideration. Thank you. Thank you.
Is that all you have? All right, thank you. Ms. Walker, you actually only used up 9 minutes, so you have 6 minutes if you want.
I won't subject the honors to 9 minutes. All right, if you may please the court. To answer the question Your Honor just asked, it was 2019. That was the last time Mother made any allegations. And what happened was she had spoken to authorities in Kentucky because she was there then. They opened an investigation. The cabinet in Kentucky opened an investigation, and they recommended to her, not knowing what Hamilton County had said, that she do that, and she did that. And then the court ordered Mother to undergo psychological evaluation, which she did. The only thing the psychological evaluation found was that Mother had distrust of Father. There wasn't any overwhelming psychosis or anything odd about it all. So just like with the minor arguments of breastfeeding and co-sleeping, Mother's accusations against Father were also stale at that point. Mother was not at that point making strong accusations against Father. She hadn't taken the child anywhere to be investigated since 2019.
What was the date of the hearing then?
I believe the final hearing was April 2nd, 2021.
And that's when Mother said that she no longer believed that Father was abusing her child?
Yes, I think it's, my notes say it was on page 8, line 16 of the April 2nd, 2021 of transcript.
Okay.
So, again, because the court at some point disliked, and for good reason, maybe perhaps, Mother's accusations without hard evidence, the court seemed to dismiss everything she said. So therefore, when Mother said at 2021, I don't think this is an issue anymore, and the court heard that, the court didn't take into consideration, I think, because the court was relying on the stale evidence that heard from the GAL. I don't want to appear to be blaming the GAL for everything. With COVID going on and people restricting their homes, everything, I'm sure it was complicated. But I think the GAL, knowing that she had a duty to respond, to investigate, I apologize, and to investigate, definitely she should have at some point asked the court to do a further investigation. Obviously, either parent could have as well, but in this case, because the GAL is the one who signs the report and the one who testifies about her report in court, She should have made sure all her evidence and all her observations were still relevant and up to date.
So you're saying that the GAL didn't have any further because I thought Appellee's counsel just said the GAL maintained contact with both sides.
The GAL made, to the best of my knowledge, Your Honor, the GAL made no visits to the house prior to the very first hearing on this case, prior first trial date of this case, which was in 2019.
Visits to the house, but what about further contact in some way, such as phone calls or?
I can't speak to that, Your Honor.
Okay.
To go back to the length of time, counsel was talking about how we all know, we all get our schedules out and set them. However, there are magistrates and judges who will say, this has to be done by this date. You need to find time or get someone else to cover this for you. I've had that, everyone's had that happen to them at some point. There are, Rule 40, I believe, it's Rule 40, has some guidance for cases. Once you get to the 180-day mark, the court does, the Rule 40 does want the administrative judge to take a look into things. And there's no evidence whatsoever, of course I wouldn't have access to it, of the administrative judge ever taking a look at this case and saying, whoa, this has gone on too long. If you look at when COVID essentially lifted in July, the case wasn't set until November. 4 months later, in those 4 months, nothing could happen in the case legally. And it's confusing as to why that could happen when the court, knowing that COVID had a lot of cases sitting, the court didn't do something that permitted it to hurry up and get caught up, whether it be Saturdays. There's lots of things the courts could have done that didn't do for the best interest of the child. In this case, it affected the child negatively by changing the child.
I think part of the issue with your argument, though, is you're putting the burden on the court when no one is saying, we need this decided right now. Like, none of the parties are telling the court, this delay is too long, don't keep it going. Like, there's urgency here. So, like, I feel like that's part of the disconnect here is if the party is being disadvantaged by the delay, it's incumbent upon the party to raise that to the court in some fashion.
I understand what you're saying, Your Honor. If you look at the transcript, mother herself, in her answers, states that she's not breastfeeding anymore, she doesn't believe father committed sexual aggressions against the child anymore, and she's no longer co-sleeping. And the child is no longer resisting going to the car and walking to the car. She's now able to walk to the car herself, to father's car. So mother, in her knowledge, was relying on her testimony to be believed by the court and to be understood that the things that the other side was presenting were no longer true. Again, unfortunately, the court chose to go with the stale evidence as opposed to relying on mother's testimony as to what the case was that day. All right. Thank you, Your Honors.
Thank you. Thank you both for your arguments this morning. The case is now submitted and we will issue a timely decision. Thank you. Have a good rest of your morning. Next case up is Watering versus CBTM.
Is not on the docket for tonight, folks, just because that is, in fact, where I am calling it for this evening, even though there are 73 people here tonight. What I want you guys to do, as I've said many times today already, thank you so much for being here. Make sure you've clocked in for your shift by hitting that like button. I guess the dislike button, you could use that if you really wanted to. Subscribe if you're not already subscribed. We have a lot of fun stuff going on. We have Christmas in July, which is coming up for the channel, where I want to receive cards from you guys for Christmas in July. It's going to be a new tradition that we do. Oh my gosh. We can't do it this year, but next year we can do a Secret Santa Christmas in July. It'll be so fun because everyone's so busy in December. Also, what else do I need to tell you guys? I don't really remember. Yeah, YouTube Daddy likes engagement. Sashina, thank you so much. So what that means is after this, you could go leave a like and a comment on the video. That would be so helpful. I really appreciate it. Um, just Daylight is making a card, and that makes me happy. Oh, the P.O. box is available now. I am so excited to let these mail people get to know me. And seriously, guys, there is so much good content and creators out on YouTube right now. And you know my favorites, they're listed on my channels page. So I want you to remember that I love you, that I'm proud of you, and that I'll see you tomorrow. But I hope you have a really good night. Oh, of course. I was like, wait, I'm forgetting something. Don't be a dick. Give the like a click. Please and thank you. Bye, guys. Seriously, you rock. Aw, you guys are all lovely. Lovely, lovely, lovely. Bye.